The danger of AI citation, why the Supreme Court overturned NCLT's decision? Everything looked normal in a courtroom. Lawyers were standing with their files, the judge was reading the order, and outside, the future of some company was at stake. But hidden inside that judgment was something that was even more dangerous than any witness, document, or contract. The names of some old court decisions were written there. To look at, they seemed completely real. The citation was also in a legal style, and the language was confident too. The fear begins right here. If a court's decision is based on such cases that never even existed, where will the foundation of justice remain? And the curiosity is, whether AI is now a helper in legal research, or can it become a silent poison for the justice system without verification? The Supreme Court recently gave a very strict message on this exact danger in an important judgment. The matter belonged to an insolvency dispute connected with SL Infra projects. The name of the case was 𝐼𝐮𝐻𝐵 vs 𝐮𝐻𝐵 Bank Limited. This matter was connected to a Section 7 application of the Insolvency and Bankruptcy Code. 𝐮𝐻𝐵 Bank had given an application in NCLT on the basis of financial debt and default. The corporate debtor side was connected with SL Infra projects. NCLT admitted the application, an interim resolution professional was appointed, and the order went in the direction of the insolvency process. Then the matter went to NCLAT. NCLAT also supported NCLT's view. From the outside, it looked like ordinary insolvency litigation was moving forward. But when the matter reached the Supreme Court, a shock came to light there. There was a problem in the very judicial precedents with the help of which the reasoning was made. The Supreme Court found that some cited judgments were non-existent. Some citations were connected to real cases, but the paragraphs attached from them were not in the reports at all. Meaning, this was not a simple typing mistake. This was such legal material that looked real, but would break down upon verification. In the world of AI, this is called hallucination, meaning, AI creates such information that looks confident and polished, but is not true. This is even more dangerous in the legal field, because a fake precedent is not just wrong information, but can affect the rights of a person or a company. The court clearly said that the judicial process cannot run on fake or hallucinated material. If the foundation of a decision is on imaginary law, then that decision cannot stand. The Supreme Court set aside the orders of NCLT and NCLAT. The Section 7 application was restored back before the NCLT for fresh consideration. Understand the most important thing here. The Supreme Court did not say whether the bank's claim is right or wrong. Merits were left open. The court's concern was that the decision must be based on genuine legal authorities. If the law itself is fake, then no matter how beautiful the reasoning looks, it is unsafe. This case is historic, because AI hallucination is now no longer just a mistake of students or office drafts. It has reached a court order. Sometimes a lawyer makes a draft with AI, sometimes a researcher searches for case law, sometimes an assistant takes out a quick summary. This very convenience can become a risk. AI is fast, but truth is more necessary than speed in law. If an answer made in a second turns out to be fake, it can spoil years of litigation. The Supreme Court said that courts must maintain zero tolerance toward AI-generated precedents without verification. This means that the output of AI can only be a starting point. Final reliance should happen only when the citation is verified from an official source or a trusted law database. The court gave a strict message to advocates too. If an advocate cites AI-generated fake judgments in court without verifying them, it can be professional misconduct. This line is very big. Now no lawyer can make the excuse that AI gave it, therefore I used it. The person making a filing in court is responsible. Even if the machine makes a mistake, the accountability will belong to that person who presented it without verifying it. The Supreme Court cautioned judges as well. If a judge relies on fake or hallucinated AI material considering it a precedent, then this is a serious lapse. Because the signature on a judgment does not belong to a machine. A judgment comes with the authority of a human institution. AI can generate an answer, but the final burden of justice remains only on the judge, lawyer, and the legal system. Another interesting point came up in this case. According to the record, it was stated from the bank's side that its lawyers had not cited the disputed fake authorities. The Supreme Court noted that the tribunal had obtained them from its own research. This point makes accountability even more complicated. If the fake material had come from the advocate, the path of blame would look easy. But when the material came inside the adjudicatory process, the question became bigger. Who did the research? Was an AI tool used? Was the output verified? Did NCLT check it? These questions connect with the process of the justice system. The failure of NCLT was important too. The appellate tribunal failed to catch the fake authorities while examining the NCLT reasoning. Meaning, hallucinated law moved from one level to another level. This very thing felt more alarming to the Supreme Court. If a fake citation remains in a draft, correction is possible. But if that same citation goes into a signed order, its effect begins in the real world. In an insolvency case, such an order can place a serious effect on company control, moratorium, creditors, and management. Therefore, this was no small legal technicality. This was an institutional warning that AI cannot enter the legal system without guardrails. The Supreme Court also asked the Bar Council of India to examine the issue. If needed, rules and a disciplinary framework can be made. BCI is the regulator connected with the professional conduct of lawyers. If clear rules are made on AI misuse, then accountability will become sharp for advocates in the future. This is a new era in the legal profession. Earlier, a lawyer's mistake looked limited to a wrong citation, outdated law, or misreading. Now the new mistake is citing such a case that never even happened. AI-generated confidence makes this mistake even more dangerous. Because a hallucinated citation does not often look weak. It comes with proper party names, SCC-style references, paragraphs, and a legal tone. An overworked lawyer, intern, or researcher can look at it and assume that it is real. This is the most dangerous characteristic of AI hallucination. It writes a lie not with doubt, but with confidence. Earlier, the discipline of verification was naturally there in legal research. A book had to be opened, a database had to be searched, a judgment had to be read. AI gave a shortcut. But the shortcut created a new trap too, where the answer comes first and verification is forgotten later. The Supreme Court's message is exactly this: verification is not optional in law. Every citation, every quote, every precedent must be cross-checked. If any judgment is stated to be of the Supreme Court, it must be found on an official record, a reliable legal database, or an authenticated source. Even if the citation is real, the quoted paragraph must be verified. Because many times AI attaches a fake paragraph along with a real case name. This very thing was a part of the problem in this case too. Some authorities were completely fake, and in some, invented content was attached with genuine citations. It is necessary for common people to understand this matter too. AI does not just give wrong answers. Many times it gives a mix of half-truth and half-lie. In the legal field, even a half-lie can do full damage. Today, the use of AI is not completely banned in courts. The Supreme Court did not say that AI can never be used. AI can help in translation, summarization, document sorting, research assistance, and accessibility. But AI cannot become a judge. AI cannot become the final source of a precedent. Accepting the output of AI as law is dangerous. The court essentially said that AI is a tool, not an authority. Help can be taken from a tool, but trust can be placed only after verification. This matter is important not just for lawyers but for students and content creators too. If you create a legal script, business advice, health information, or financial content with AI, definitely do a fact check. Because the audience can place trust in your words. And wrong legal information can lead someone toward a wrong complaint, a wrong deadline, or a wrong decision. Responsibility has not reduced with the coming of AI, it has increased. Earlier, finding a mistake was the writer's job. Now catching AI's mistake is also the writer's job. Training will be necessary for the judiciary too. Judges, tribunal members, clerks, and researchers will have to understand how to verify AI output. In the future, court systems will perhaps require citation checking tools, AI use disclosure, and verification protocols linked with official databases. But technology alone is not the solution. In the end, human discipline will remain the biggest safeguard. If a researcher is in a hurry, there is a workload on a judge, and a lawyer has a deadline, then the risk of hallucination slipping in increases. Indian courts already struggle with massive pendency and workload. In such a situation, the attraction of AI speed becomes even stronger. But if speed brings along wrong law, it does not make justice fast, it makes it fragile. The symbolic impact of this judgment is very big. The Supreme Court has shown that the legal system can welcome AI, but will not place blind trust. A fake precedent in the world of law is like a counterfeit note. It looks real, circulates for a while, but breaks all trust when caught. Courtrooms run on trust. A judge trusts that the lawyer is giving the correct citation. A lawyer trusts that the database is reliable. When AI hallucination enters this chain, every link becomes suspicious. Then the court will have to verify every citation and the process will become slow. Therefore, fake AI citations are not a problem of just one case, they are a problem of the trust of the entire system. The Supreme Court has drawn this exact boundary through its judgment. Use AI, but do not leave it unchecked. If an advocate cites, let them verify. If a judge relies, let them verify. If a tribunal researches, let them trace the source. This decision can change legal education as well in the coming time. Law students will now have to learn not just to read case law, but to test AI-generated legal output too. Firms and chambers might have to make an internal AI policy. Who will use the tool, how the citation will be verified, and who will have the final responsibility. Courts too might have to adopt a culture of disclosure. If AI-assisted research has been used, maintaining a verification record can be useful. But the biggest thing is of ethics. Words are not just words in law, they can decide someone's liberty, property, reputation, and future. If a fake citation pushes a company into insolvency, keeps an accused away from bail, or stops a victim from justice, then the damage is real. AI has given a powerful tool to the legal profession. But along with power, caution is needed too. This decision of the Supreme Court is not against AI, it is against careless AI use. This judgment says that technology can help the court, but it cannot become the soul of the court. Because justice is not just pattern matching. Justice is a combination of facts, law, context, conscience, and human responsibility. A machine can make language, but it cannot feel fairness. AI can make a citation, but it cannot swear an oath to its truth. Therefore, whenever any legal document is made with AI, the first question should be, is this true? The second question should be, what is its source? And the third question should be, if this turns out to be wrong, who will be responsible? The Supreme Court has made the answer clear in this case. The responsibility belongs to the human, and tolerance for fake law must be zero. Today this warning has come for courts, but tomorrow this will apply to every profession. A doctor will verify AI advice. A journalist will check AI facts. Teachers will test AI material. A business owner will not blindly sign an AI contract. Because the more powerful AI becomes, the more the need for human verification will grow. The SL Infra Projects case has shown us a scary mirror. If a fake citation can enter a judgment, then no professional document is safe. But there is hope too in this story. The Supreme Court caught the mistake, set aside the order, and alerted the system. Now the challenge is that the warning must not remain just a headline. It will have to be turned into training, rules, and daily discipline. Because even one fake precedent is not small in the justice system, it can poison the entire reasoning. And when a lie enters the foundation of justice, the building does not fall first, people's trust falls. Therefore, the biggest lesson of today is exactly this. Take help from AI, but do not trust it with closed eyes. Because an algorithm does not announce a decision in court. In the end, a human delivers justice, and the human alone has to pick up the responsibility of the truth.
If this video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies, public sources, and public opinion. We make every effort to verify and validate each fact as much as possible. But in case of any possible error or dispute, the responsibility lies with the respective sources. Our only aim is to present you with a correct and trustworthy perspective so that you can understand any topic better.